Hello, everybody, and welcome back to SEC Roundup. I'm Nick Morgan, the co-founder of ICAN, Investor Choice Advocates Network, and the host of today's episode of SEC Roundup. We are joined by a fabulous panel today to talk about some of the SEC and other related cases to watch in 2026. Let's do some introductions here. So we'll start out with Sarah Concannon. Sarah, obviously a frequent contributor to SEC Roundup, is the chair of the SEC Enforcement Defense Practice at Quinn Emanuel and a former senior enforcement official at the SEC. Sarah, thank you for joining.
Thank you, Nick. Good to be back.
Professor Kevin Douglas, associate professor at Michigan State University College of Law and a member of ICANN's advisory board. Kevin, thank you so much for joining.
Thank you for having me.
And finally, JW Verret, associate professor at George Mason School of Law, a former member of SEC's Investor Advisory Committee. JW, thanks for coming on.
Thanks for having me, and thanks, ICANN, for everything you do to help people.
Well, it's great to have such a knowledgeable cast panel here to talk about some of the cases. I think there's a narrative out there with the administration change, Paul Atkins now at the chair of the SEC, that the enforcement division has gone away. Their number of total cases brought in 2025 was lower than in 2024, and some people gasped and grasped their pearls and said, "My God, what's happening?" I'd like to hear any thoughts you have on that. My perspective is that anytime you're going to change gears and reevaluate the viability of certain legal theories, and there's going to be a slowdown before a speed up. So I didn't read too much into the drop in numbers in 2025. I don't expect that trend to continue in 2026. But there are some specific cases out there that often fly under the radar and may have great import depending on how they go in 2026. Sarah, I wanted to start off with you. During the last administration, the Enforcement Division brought a number of cases alleging that people engaging in certain trading activities should be registered as securities dealers. So these became known as the dealer cases. One of them that I'm hoping you can shed some light on and tell us about, although there may not be too much to report, is the Carebourn case. Can you tell us what's going on there and why should we care?
So I'm amazed that in this esteemed crowd that you're starting with me, but we'll start with me and we will build up to my esteemed professor colleagues here. So Carebourn it's a fascinating procedural case. If you just want to trace through, some of us when the new administration came in said what's going to be really interesting is what happens with litigated cases, what happens with cases on appeals. Things that are still in the investigative process. The new administration has a lot of options to kind of quietly make those go away under the radar as there are policy shifts. But if something's litigating, if something's on appeal, they have to be much more actively out there. So Carebourn, I think it's fair to say, is likely to be the last of the 15A cases under the Atkins administration. And really, almost by virtue of the defendant's refusal to permit the SEC to dismiss, which is one of the things that just makes the case procedurally fascinating. So Carebourn was an unregistered broker-dealer case that was filed under the Gensler administration. In September of 2024, on summary judgment, the district court held in favor of the SEC, imposed $12 million in disgorgement. And the case was then appealed by the defendants to the Eighth Circuit, really looking on the part of the defendants for a definitive statement by the Eighth Circuit Court of Appeals. Is this particular fact pattern unregistered broker-dealer activity or not? Obviously advocating strongly that their fact pattern does not fit the parameters of any sort of unregistered broker-dealer activity. The SEC, on appeal, requested that the Eighth Circuit remand the case back to the district court, which the Eighth Circuit then did.
Can I interrupt you there for a second? Isn't that a little nuts? It's Carebourn's appeal and the SEC, the party responding to the appeal, asks for it to be remanded. I just think that I can't recall an instance in which that's ever happened.
Yeah, completely nuts, completely unanticipated. I thought kind of in the appellate process, I had actually given some interviews back at the time saying, once it's on appeal, that's not the SEC show anymore. They're not driving the bus. They don't get to call the shots on whether or not the case does or doesn't proceed. Here, they managed to convince the Eighth Circuit that the Eighth Circuit could, wash its hands of it by permitting them to remand. Eighth Circuit remanded back to the district court, where the SEC promptly moved to voluntarily dismiss without prejudice the underlying charges. This was during the same period of time that they were doing a variety of dismissals of litigated dealer cases, both with prejudice and without prejudice. The SEC claims that they were unable to reach agreement with the defendants with regard to certain other terms of whatever this dismissal would be in order for them to dismiss it with prejudice. Therefore, they moved to dismiss without prejudice. The defendants then moved for sanctions and to have the case dismissed with prejudice instead. So the defendants are essentially saying a few different things. One, this case never should have been brought in the first place in the exercise of prosecutorial discretion. Two, that's absolutely clear, given some statements that Commissioner Ueda had made around unregistered broker-dealer activity. And three, that if you look at the now vacated dealer rule, where the Fifth Circuit said that the SEC had exceeded its authority with regard to the dealer rule, that this also shows, even though that postdated this litigation, that the case never should have been brought and that essentially it's gross SEC overreach. I suspect at the end of the day, the real objective here, if I had to read into perhaps two things. One, defendant wants to drive good law, walking quietly away, accepting a voluntary dismissal without prejudice does not leave the landscape clear as to what is and isn't good law. Right now, the district court did hold in favor of the SEC at summary judgment. The appeal was remanded. So that's kind of the statement of the district court with regard to their particular fact pattern right now is this fits all the parameters of dealer activity and you're subject to a $12 million disgorgement remedy there. So permitting the SEC to quietly walk away, not in the best interests of anyone, including this defendant, really knowing what the law is in this space. But two, if it's a voluntary dismissal and you're not eligible for compensation under the Equal Access to Justice Act. So I suspect that there is also an objective on the part of the defendant to have the case dismissed with prejudice, claim that they are a prevailing party and then pursue their fees and costs in association with the litigation, which has been quite protracted and, ultimately has cost them reputational effects and other things that they flag in their briefing. So current state of play, I think it slowed down a little bit during the shutdown. Everything is now currently briefed. So you have cross motions from the SEC to enforce its motion to dismiss without prejudice, cross motion from the defendant to dismiss with prejudice, but also find sanctions against the SEC, saying the case never should have been brought in the first place. If I had to guess, and the great things about these webinars is you can play this back a few months from now, you've heard from the court. If I had to guess, the court's going to dismiss. Court is going to dismiss possibly with prejudice, because I think the arguments there on why the statute of limitations is running and there just shouldn't be any specter of this case ever being raised again against the defendant. I think they lose out of hand on the EJA and the sanctions claims. I think they're going to say the action was substantially justified and that, as of that point in time, the law was consistent with the SEC's presentation of the law and what they alleged in the complaint. And ultimately, a district court did find summary judgment. Now, I think, Nick, you have a theory that maybe the case comes back, that they dismiss without prejudice, the SEC waits out the statute of limitations, there's an administration change, and then this hits the docket as the next or first, I suppose, broker-dealer unregistered case in the new administration. I think there are probably statute of limitations problems there. And the SEC, while they sometimes, I think we've seen it in Gentili and some of the Jarchese, some of the really long run cases that have worked their ways up to the Supreme Court and then come back at various levels. So I can't say the SEC isn't vindictive when it comes to some of these cases, but I suspect that what they want is for this one to go away and to go away permanently, but not in a way that challenges their ability to have brought the underlying action, or subjects the SEC to potentially paying all of the defendants' fees and costs over the course of a prolonged litigation.
Yeah. Yeah. I think you put your finger on it right there with the EJA fees issue. The current commission, most of whom have spoken on this issue very critically that the SEC should not have brought these cases in the first place, are now in the position of defending having taken the case in the first place. Because if they failed to make that persuasive, then the commission may end up paying fees. So that's an awkward position to be in. And I don't know that the SEC so much would go after Carebourn specifically, but I do think, given the unsettled state of the law, where you've got one Fifth Circuit ruling on this related issue, rulemaking issue, and then the 11th Circuit cases, it's, I think, highly likely that a different administration would just continue bringing this type of case under the similar fact pattern. So that does not give the folks in the alternative investment space any comfort that the issue's been resolved. So, well, thanks. Well, that is definitely one to keep an eye on for 2026. So we'll check back in and rewind the tape and see if your prediction is correct, that the case gets dismissed, perhaps with prejudice. All right. Well, let's talk about another slow brewing but very important case out in the Ninth Circuit, my neck of the woods. Kevin, you and I have done some work in the form of amicus briefs in connection with the SEC's first, and I think only, shadow insider trading case. I'm not aware of another one. It's the defendant's name is Panuwat. So the case has certainly been around for a long time, but as yet not fully resolved. Can you remind us a little bit about what that case is and why we might want to keep an eye on it in 2026?
Sure. You have a gentleman. It's the Securities and Exchange Commission versus Matthew Panuwat. Panuwat was an employee at a very small publicly traded pharmaceutical company that around 2016 was about to be acquired by a much larger pharmaceutical company. And he learned about the negotiations between his employer and the larger buyer, and also may have heard from partially inferred from that if his company is up for grabs, then in all likelihood, a third company, another small pharmaceutical company similar to his own, is likely to also be a target once the announcement for his company's acquisition is announced. Whether it was a full independent inference on his part, or whether he overheard or was privy to information from the investment bankers working on a deal, mentioning this third company and raising the issue that, hey, they're very similar to his employer. Either way, he ends up investing in that third company. The announcement about the merger between his and the second larger company is made. The price of the third company's stock goes up as well, and he is able to generate a profit of a little over $100,000. The Securities and Exchange Commission brings an insider trading case a few years later. A jury agrees with the Securities and Exchange Commission and finds Mr. Panuwat guilty, and he gets fined something like a little over $300,000, because the way insider trading penalties work is that you get hit with 3 times the profits generated or the losses avoided. So he made about $100,000, gets fined about $300,000. And what's interesting about this case, 2 different things are interesting about this case. It's the fact that historically, when insider trading charges are brought, it's against someone who's either trading in the stock of their own company, or they're trading in the stock of a company that their company is interested in. Either there was the furthest one away was like the Wall Street Journal's, one of their journalists would produce articles about which companies are stocks to invest in, and he started tipping people as to which companies were going to be recommended. And at least the Wall Street Journal was interested because there was a part of their column that's being published about which companies are attractive or not attractive. More common is something like one company wants to take over a second company. You work for either the lawyers of the buyer or for the buyer itself, not the company that's a target. And so that's usually the framework for bringing insider trading claims. You work for the company whose stock you want to trade in, or you work for a company who has some interest in the stock you want to trade in. You learned about the pending change in price from your employer because of their interest in that second company. And here, the one difference is what we're calling shadow trading, is that we're dealing with a third company that had nothing to do with his company or the second that wanted to buy his company. His company wasn't interested in buying the competitor. The buyer of his company was not interested in buying the competitor, or at least that wasn't a part of the deal being negotiated. But what And so it's shadow trading, not regular misappropriation theory, but they call it a version of that second theory. You work for one company, you buy the stock of a second company based on what you learned at your company.
Right.
The second thing that makes it novel is that they insist that a part of why he's guilty for insider trading is because his company had insider trading policy, one that he signed, saying that you're not allowed to trade in the stock of other publicly traded companies that we have a significant relationship with, including customers, suppliers, and competitors. Right. And it might have been that significant relationship thing might have been an independent thing. Companies we have a significant relationship with, or publicly traded customers, suppliers, or competitors. And so the SEC says, hey, he violated a duty, not only a regular standing fiduciary obligation, but also one that was enhanced by this contractual provision that he signed. And so he breached a duty to his employer and traded in information he learned from them. And that's insider trading. He's penalized. Jury says yes. He appeals the case. Well, let me throw this one thing in there. That part about the employee policy playing a role in it, I guess it's the SEC was so happy about it that later on, within a year or so, they passed a rule requiring that all publicly traded companies essentially create and publish their insider trading policy. Pros and cons in that some people, made the restrictions tighter, some made it looser, but still they were so happy about it. They kind of try to put themselves in a position to win more cases like it. Panuwat loses. He appeals the case. He's on appeal to the Ninth Circuit. Interestingly, his attorney's argument as to why the case should be thrown out is that if you read the insider trading policy, that the trades that he made were not covered by the policy and were totally should have been considered allowed on based on proper applications of contract interpretation, that the court should see his trades as allowed by the insider trading policy. I don't know how well I buy that or not. As Nick said, one of my personal interests in the case is that ICAN put together an amicus brief related to the case, and in that amicus brief, we actually wrote it in support of Mr. Panuwat and made at least 3 arguments as to why we think the case should come out in his favor. One, we said that the theories that they're using to penalize him kind of improperly try to have federal law supplant and override state agency contract and employment law, i.e. the laws that define fiduciary obligations for the employees of companies. We said that the law, basically in the way it expanded the law, kind of treats insider trading standards as so vague that it's probably going to chill legitimate trading, therefore should be considered against public policy. And the last thing we said is that they just didn't have the statutory authority to expand the conception of insider trading in that way under federal securities fraud statutes. The SEC has, right now, we're only at the point where the Securities and Exchange Commission has submitted their brief responding to the appellate brief and all the amicus briefs. They actually mentioned our brief in their response and specifically responded to this claim that we made that you should look to state law to figure out the scope of the fiduciary and other obligations that Panuwat had. They say, no, you shouldn't have to look to state law. There's some kind of common law standard of what those fiduciary obligations are. Luckily, there's a circuit split on that question. You got the 6th and the 7th Circuit saying, yes, the gaps in what qualifies as fiduciary obligations for federal securities law are going to be defined by state law. First case from 87, another case from sometime in the early to mid 2000s. And then you got a 2nd Circuit case from about 2014 saying that it's the standard or the fiduciary obligations should be defined by federal common law. I'm not sure which way the 9th Circuit is going to go, but either way, I hope the outcome comes to the notice of the U.S. Supreme Court. And the reason I hope this happens is because the court has been on this trend of pushing back against creative interpretations of what qualifies as property in a bunch of mail and wire fraud cases. And I'm hoping that trend could spill over into securities fraud. And because the insider trading, the 2 most popular rationales for insider trading are sold as a way to protect the property rights of the employers in material non-public information. I don't buy the justification, but it's a well-respected justification both by people who promote and support the prohibition and for people who oppose the prohibition and think it should be either narrowed or eliminated. But either way, I'm hoping that the court takes this up, and just like they have done with the mail and wire fraud cases, one called Kelly from United States from 2020 and one called Emanuel v. US from 2023, I hope they say, hey, we need to pull back on these creative interpretations on what counts as property and therefore what counts as laws aimed at protecting property. And while, those dates, 2020 and 2023, might make it sound might be all the result of President Trump's appointees during his first term, in actuality, this trend started in 1987. And the first time the court said, hey, whatever you guys have been doing for the last 40 years with the mail and wire fraud statute vis-a-vis property is wrong. And the case from 2020 cited a case from the year 2000 as to why it thinks the extension that's happening is a problem. So it's a long trend. It might be accelerating. Hopefully it accelerates in such a way that when the Supreme Court thinks about shadow trading and this idea that your employment agreements can modify what the rights and obligations, hopefully it leads them to say, hey, we need to think about this. If we're going to say we're doing this because we're protecting property rights, let's actually treat this like a property issue for real and see what the property rights are and how we actually reasonably protect property interest. Hopefully that's the way it goes.
Yeah, well, from your lips to the court's ears. But, I think an interesting aspect of this Panuwat case is the broad level of interest it's received, not just from public companies that are concerned about, well, should our policy, our insider trading policy be this or that, but also as to how the SEC might use this theory of insider trading in other contexts. One of the amicus briefs alongside ours was from the Alternative Investment Management Association. I think the hedge fund folks are really concerned. They might get information about one company and be held in hindsight to be restricted with regard to other companies. So I think there's a lot of interest in this case. The SEC's brief, the way I read it, was sort of like, nothing to see here. This is just normal insider trading, perfectly consistent with everything that's come before. So we'll see what the Ninth Circuit does with it. But thank you for that great description, Kevin. And again, briefing is complete or near complete, and Ninth Circuit should issue a ruling here, hopefully in 2026. So keep an eye out for Panuwat. Well, the SEC, we've talked about two cases in which the SEC in the prior administration brought enforcement actions, and the current administration is having to deal with them in some way. I want to pivot a little bit away from that to crypto. JW, one of the things that the current administration has done is reevaluated the SEC position vis-a-vis a lot of these crypto assets and digital assets, and the SEC has dropped a number of enforcement actions. But that doesn't necessarily mean that crypto companies are no longer bogged down by securities regulation and enforcement. Can you talk about one of the cases that's still around against Coinbase? It's specifically the Oregon state case.
Sure. And before I start, I just want to thank you, Kevin and Nick, both for the work you're doing on the Panuwat case. I mean, it doesn't feel real and human when you teach insider trading and securities law, but the pattern of so many cases where new law is made in a gray, indeterminate area that very much labels people as bad actors. New law is made on the backs of new defendants. They didn't know that what they were doing was illegal. Absolutely not. And the SEC just makes new law. And new law that has a corollary for DOJ criminal enforcement. You can go to jail for something that it's not clear was illegal. And I would have said as a securities law professor, I don't think was illegal. That's just horrible outcomes. And I'm grateful that you're here doing this, and it's kind of ironic that an agency whose mission is to help disclosure of information to price discovery, their enforcement function, at least on the insider trading component, does exactly the opposite. Right. It's a funny irony. It's also kind of sad irony when you see these people. So thanks for the work you're doing there.
You're super welcome. I was going to build on that point. It's someplace I've written that to me, it reminds me of like these old school divine right of kings arguments where it's like, you folks can't commit murder, but me, Henry VIII, when I kill someone, it's cool.
But I'm a policy, right?
Yeah, it's just the sovereign doing the sovereign's thing. So you're right. Like clarity for us, but not for them. It's disturbing.
Yeah. Well, thanks for the work you do. So in Coinbase, a little bit of history is necessary, but I won't bog down on the full history of the crypto policy debates going back. But just on the Coinbase case, Coinbase begged and pleaded the SEC to give it a license for whatever was appropriate. Coinbase went through an S1 process and told the world what it was going to do, and did an IPO, and that process went through without much friction. And then, the politics shifted post FTX. FTX was a major donor to Biden, the largest single donor to Biden. The politics shifted, and I think it's reasonable to say the directive to Gensler was blow it up, destroy the industry. It's and the tool he used was the Howey test and failure to register, and he brought a whole slew of cases that were registration only cases where there's no fraud involved at all. And most of those have been withdrawn, though if there's time, I'd love to talk about SEC versus Justin Sun, which I think is a really complicated case for the SEC that they also need to drop because for the same justifications that they dropped the number of cases. But anyway, so this SEC versus Coinbase case is dropped. A lot of interesting history there where Coinbase begs the SEC for a public rulemaking. They file requesting public rulemaking. The SEC ignores them. The SEC brings this case for unregistered securities, even though all the tokens on there are pretty clearly, I would say, not securities under the secondary market holding in SEC versus Ripple, and SEC's sort of halfway or maybe 2/3 loss in that case. So Oregon, the case is dropped in the new administration. Oregon picks up a similar case that's incredibly more expansive than the SEC's theory of the case. I'm not an expert on Oregon securities law, but I understand it to be somewhat informed by the federal securities law apparatus. And Oregon's Attorney General is also leaning on something else in the filing here, this idea that state material aid doctrine, material aid to the distribution, sale of securities, they've created a theory so they've I guess tried to learn from the initial back and forth of SEC versus Coinbase before the case was dismissed. And they've expanded the theory to encompass everything that this secondary platform for the trading of what I would call commodity crypto tokens. They've expanded the secondary platform's activity with the underlying source of the developer initiatives that keep the blockchain going that's associated to the token. It's just a very expansive material aid doctrine, or you can think of it as a kind of a conspiracy to sell unregistered tokens. That's not the word of the theory, but it's a similar kind of idea and a similar dynamic I think you've seen in a lot of criminal cases where a prosecutor's definition of conspiracy is so incredibly, it becomes ridiculo ad absurdum arguments very, very, very quickly. And I would characterize, editorializing, I would characterize the Oregon theory in that way. There are a number of tokens thrown in, alleged to be securities here, a longer laundry list than the SEC put into its case against Coinbase or the related insider trading case where the SEC alleged a number of tokens were securities. I think there were 31 tokens alleged to be securities. I'm pretty familiar with most of them because I use some of them in my daily life. The NEAR token, the Filecoin token. One word about what is crypto, sort of my 1 minute Thanksgiving speech to my in-laws when they tell me, what is this thing? I don't really talk about Bitcoin a whole lot. I don't really talk about, is it money or not, or all that stuff. I really talk about the best use case for this technology is it helps to find a way to finance the development of open source software outside of central corporations. That the traditional model of developing software is a central corporation issues stock, uses the stock to develop and pay software developers who then create IP, and then the single company that's publicly traded, licenses the IP and uses the value of the IP to earn returns. Okay, so some developers like to develop in a very different way. There are a lot of negative things that come with that model, including the uses of data and social media and stuff like that. So a lot of cypherpunk-oriented software developers have a different way of doing things. They like to develop things open source and give it to the world, create something and give it to the world. It's hard to finance that. I love the Firefox browser because it's open source developed, but there aren't many pre-crypto. There weren't very many good open source projects that could develop and finance themselves. So crypto finds a way to do this because the crypto token on a blockchain that is immutable, that you can trust the final compute of distribution on the ledger between different people participating. The token becomes a way to pay for the scarce resource of computational energy on the blockchain that makes the computations happen, that memorialize the transfers. And then because it has utility value, it also has side speculative value as a sort of a beanie baby sort of speculative thing. But that speculative value that flows from the utility value also makes it useful as a way to compensate developers and people who contribute to the project. None of that is fraudulent. At least I wouldn't call it fraudulent at any of the tokens mentioned here except for two. One that is a Luna token that was part of a fraud case. Another that was wrapped a wrap version of the Luna token. But none of these, I think, involve anything fraudulent. In fact, they all work pretty well, but are all designed in this way. Open source projects, no centralized individual controlling it, no balance sheet, no income statement, no information you could really put onto an S1 if you would call the project a part of a security. I think that Luna tokens were thrown in there because it makes for an interesting story. Though even on that, and speaking as someone who lost a lot of money with Luna, I knew what that experiment was. I don't feel like I was lied to about what that experiment was. I bet on it, threw some money to bet on it, and it didn't work out. I learned my lesson. I'm not going to bet on asymmetric stable coins that aren't backed by anything, really. But I didn't really see any fraud even there. Though ultimately the main guy behind it was found guilty of fraud. So we got a long list of tokens. We got an expansive theory that brings in a kind of a conspiracy-esque doctrine that tries to get around some cases that are inconvenient for Oregon here. That's a good segue to talk about cases that are inconvenient for Oregon. And I think the three cases that are come up most in the resolution of this case. One of them is the Ripple case. And the finding in the Ripple case that the secondary market transactions in the token XRP were not sales of securities is solid precedent in Coinbase's favor. And Oregon is trying to distinguish the way Coinbase works from the way those transactions worked in Ripple. Coinbase does a lot more to match orders and is a custodial platform. And so Oregon's trying to distinguish Ripple. But I think that portion of the Ripple opinion is very inconvenient for Oregon. I think there's another dismissal of a class action against Uniswap that is also helpful for Coinbase. And it's somewhat helpful. I don't think it's going to completely win the day because Uniswap is a non-custodial platform and Coinbase is a custodial platform. But I still think at the end of the day, it's a heck of a stretch to say that the secondary market where things trades and the issuer were all connected. When in some of these cases, with some of these tokens, the person who invented the project is anonymous. We don't know who they are. So I think it's a heck of a stretch of a theory. Judge Jed Rakoff's opinion in Terraform is not helpful, and he's very much in an intellectual battle with the Ripple opinion, and he makes that clear that he disagrees with it. I'm not a fan of his reasoning there, and I read his anti-Bitcoin screed in an op-ed a few months ago, and I think that tells you where he stands. And I think he's kind of historically an SEC apologist. I mean, just to put it frankly. But there's going to be a fight. There's going to be a fight in Coinbase versus Oregon, and they're going to try to use the precedent of the Terraform case. Case has been removed to federal court. So I absolutely do. When you kind of started the discussion, I absolutely do see, though, the threat of federal SEC action to allege something is an unregistered security without creating a path to register if you want to or need to, or with the new guidance and understanding and potential statutory clarity that most of these things are all commodities. Even absent that, states are coming in and bringing the same type copycat actions, I guess you can call them, sort of like how plaintiffs sometimes bring copycat actions to SEC. Right. Enforcement actions, states are bringing some copycat actions on the Gensler Playbook, and this will continue. And just going back real quick to one point from your discussion from the insider trading issues. Yeah, please. I just one more observation is, as the world is embracing this technology of prediction markets, which is an amazing ability to synthesize human information and predict the future in ways we couldn't before. That has implications for academics studying any kind of empirical question you study. This is useful. Prediction markets can help with those empirical questions. It's an amazing technology. The amorphous nature of insider trading law, not only in securities, but also in commodities, and also this weird thing where insider trading lives within wire fraud is going to be very bad for prediction markets. And I really was frustrated by Jay Clayton's kind of blithe comments about insider trading and prediction markets this week. And we could do a whole podcast on why I think that Mr. Clayton is wrong to do so, and why I think we should dedicate our lives to fighting him on that, and at least bring expansive kind of nonsense cases. But that's my soapbox for now on Oregon.
Good soapbox. You must be super popular with the family at Thanksgiving if that's the speech. Yeah. But to tie the two threads together. So one of the things that I think the digital assets community was frustrated with in the prior administration was this approach of strategic ambiguity, where it helped the SEC to be unclear about the contours of the Howey test in that case. I think the same is also true with regard to the Panuwat shadow insider trading case. It helps if you're a prosecuting agency like the SEC, it helps to have strategic ambiguity. It gives you flexibility around the edges. So nice if you're the SEC, not so nice if you live in the real world and you're trying to do something novel where it's not clear whether your actions intersect with what some future regulator might interpret the law to be. So I think you're right to tie the two things together, the Panuwat shadow insider trading, the uncertainty there, and the crypto uncertainty. I will comment on the Oregon Coinbase case only insofar as to say, we have historical precedent where states were super active in the securities markets and Congress decided, you know what, enough. We're going to establish a federal standard. It's the NISMIA statute. And I think that one possible upshot here, we know that Congress has its Clarity Act and the Senate has its comparable legislation pending, is that the federal government will just say, look, enough of this. We need to encourage innovation. And in this context, at least, the federalism debate sides on having a uniform standard. So it wouldn't surprise me if the state actions like Oregon's action against Coinbase end up backfiring and resulting in legislative efforts to impose a federal standard to keep the states out of it.
Yeah, that would be terrific. Look, when I tell my relatives, if they want to get into crypto, they're interested in experiencing the kinds of epic losses I've experienced this week in the crypto markets. What I tell them is, go buy it on Coinbase. Go to coinbase.com. Don't click on some other link that pretends to be it. And you're pretty safe there, which is a shame. If Oregon gets its way and, cuts off access to Coinbase for Oregon residents, there's going to be a lot more of the, hey, you want to buy some crypto?
Yeah.
And send me your stable coins to this address, and it disappears.
Right.
Let's have state AGs prosecute that stuff, just to plain bread and butter fraud. It pretends to be crypto, but it's not even crypto, much less a security.
Yeah.
Focus on that stuff, guys. Will do some good. Not Coinbase, which has hundreds of compliance officers helping to keep users on the platform safe.
Right. No, don't encourage back alley crypto transactions.
Hey kid, want to buy some crypto?
Right. I got some crypto.
But the longest time, what I said, the biggest risk of having your money on Coinbase was that the SEC was going to shut down Coinbase,
right,
seize all of the assets, which would include investor assets, and then good luck waiting for a distribution at some point, 2, 3, 4 years down the line for the SEC to kindly give your money back.
Yeah.
Which actually, Nick, might be a good segue into victimless disgorgement.
$5.1 billion. We'll do this pivot with that number, $5.1 billion. That is the amount of money sitting in the U.S. Treasury account designated as an SEC held for distribution account. So this is money that has been collected, not just assessed, so it's real dollars, and it's money that the SEC purports to want to distribute to victims of whatever violations were committed in connection with the cases where they collected it. The problem is, or one of the problems is, this number, this $5.1 billion, has gotten bigger and bigger and bigger every year, now to the point where it, greatly exceeds the SEC's total annual budget. The money is stuck because the SEC can't find the victims. I mean, there are probably a number of reasons why the money is stuck, but that's a big one. And one of the reasons they can't find the victims is the SEC brings a lot of actions and seeks a remedy called disgorgement, which is different from penalties, although quite punitive. It's disgorgement of so-called ill-gotten gains, the money that someone received as a result of a violation, even someone else's violation, that the SEC thinks should go back to victims. If they can't find victims, oftentimes the money sits in this account. So we can't really finish a conversation about 2026 cases to watch without mentioning the Supreme Court and a case called, where the defendant's last name is Sripech. So Mr. Sripech has a case in front of the Supreme Court. Sarah, do you want to give the spiel on Sripech?
So I'm not going to give it justice. So I'll do the 10-second version and then you can fill it out. But basically, Mr. Sripech, and I hope it is Sripech. I've been saying Sripech for a while, but brilliant minds can debate the question on the pronunciation of this soon to be very famous Supreme Court case. But the issue is that the SEC is seeking and obtaining disgorgement from Mr. Shripech for a alleged, I guess now proven, violation of the securities laws where there is no victim. And so the argument that is up before the Supreme Court and the question before the Supreme Court is, can you have disgorgement in a situation where there is an alleged ill-gotten gain, but no one to whom that disgorgement can be distributed back? And there are some related questions around this, but some of it comes down to, the concept of an ill-gotten gain, just in the nomenclature itself, really implies that there is someone out there from whom I unlawfully obtained my gain. And so it's very easy if I go out, I commit securities fraud, I convince Nick Morgan to invest in my completely fraudulent vehicle. You send me $1 million. That's my ill-gotten gain. SEC proves liability at trial. Judge imposes $1 million remedy plus interest. And that money goes back to you at some point, as I say, perhaps 3, 4, 5 years down the line, perhaps with some discounting. But the money goes back to you through some sort of distribution process. The problem is that the SEC, in a whole bunch of different spaces where there's SEC overreach, has defined things as ill-gotten gains where it doesn't fit kind of that logical fact pattern as I just defined it. So it frequently arises in your Section 5 cases. So you have an unregistered dealer case. The dealer made money by virtue of operating as a dealer during that period of time. SEC alleges that is a disgorgeable ill-gotten gain because we've proven that you were an unregistered dealer. But who are the people who are actually harmed by that unregistered dealer activity? Is it necessarily the people who paid you? Not necessarily, because there could be a scenario where you're acting on behalf of a fund, you're being paid by the fund. The actual, who was brought in, victim, would be some party over here. There's also the Section 13 cases, so 13D, where there's a late filing, failure to disclose that you were accumulating stock. Does that ultimately cause some sort of harm out there in the market? I would say no, but it's a non-fraud allegation where the SEC can and has sought disgorgement despite the failure to prove any of the hallmarks of fraud, including whether or not there's a victim. So that's the issue that Shripech is putting front and center. There are some other related interesting disgorgement issues that are not part of Shripech. So things like unrealized gains, where in the insider trading context, the SEC has often sought, despite the fact that someone never sold the stock, they have tried to seek the amount of gain that you would have realized by virtue of your insider trading activity if you had sold. There's no profit to be disgorged because the defendant didn't actually realize any sort of gain. That issue I view as related, but not front and center in Shripech. But it's basically, can you disgorge more than you have? Can it go back to some purported pool of money if there isn't a victim it can go to? Expectation is Shripech will be fully briefed by April, I believe, argued in April, and decided probably right at the close of the Supreme Court term. So we should be looking at June for a pretty significant decision on this issue to issue.
Yeah. Thanks for that, Sarah. A couple of thoughts on that. First, you hear some people say, well, if the SEC doesn't have this tool, the ability to seek victimless disgorgement, then bad people will get to keep the money. That is absolutely not true. There is a whole civil penalty scheme that the SEC uses quite liberally to impose penalties that could include the amount of pecuniary harm, for example, in insider trading cases, or rather the amount of pecuniary gain. So the penalty scheme is not impacted by this victimless disgorgement at all. And then the other unfortunate thing about Mr. Shripech, and I wish him well, I hope he succeeds, but his underlying allegations against him, which by the way were resolved by way of partial consent judgment, are fraud allegations. And as you point out, Sarah, this victimless disgorgement is most abusive when it's applied to non-fraud claims. We have a relief defendant who is not accused of violating any law at all, registration, fraud, non-fraud. And the SEC informed the court that it wanted disgorgement because it would be able to identify harmed victims from someone else's violations. We said, okay, prove it. And they were not able to. There were no victims. So nevertheless, the SEC is seeking disgorgement of our clients, money that where there are no victims. So there's a lot of sort of misinformation about this case, but it's definitely going to have a big impact on SEC enforcement going forward.
Can I throw something out there?
Yeah.
One, Sarah, thank you for talking about this case. I didn't even know it existed, but I think it builds on this idea of messed up property concepts operating in federal securities law in the sense that another way in which you can get something like disgorgement, like when it happens in civil cases, we have this concept called unjust enrichment, which it doesn't even require you to actually steal Nick Morgan's money or trick Nick out of money. You could simply, as say his employee, take a bunch of money out of the company's account, invest it in securities markets without their consent, make a bunch of money, put back what you took without consent. You can still have your employee would still have a civil cause of action to impose a constructive trust on the profits you generated with their money without their consent and take it away from you. And so to the extent that you're saying it's disgorgement as opposed to a penalty, but you haven't first identified a victim, to me, that's crazy, number one. And number two, I would think hopefully it goes further and at some point limits the kinds of cases that can be brought. You shouldn't be able to sue a person saying that they've hurt others, and therefore we need a disgorgement remedy if a victim doesn't exist when you initiate the case. But that's me and maybe a too optimistic expectation of what happens.
Well, you never know. One step at a time. So let's get the Supreme Court on board with the strip etch, and then we'll bring the Kevin Douglas case next. Well, look, this has been super helpful. I really appreciate you coming on, JW, Kevin, Sarah. I think we'll leave it there for now. I do like your idea, Sarah, of sort of looking back at this broadcast, 6-9 months from now, see how accurate we were in predicting that these cases will have a pretty big impact. For everyone else, please join us again on our next SEC Roundup. And if you want more information about ICAN, go to icanlaw.org. See you next time. Thanks all.